Welcome back, folks, to another episode of we're doing American Genesis, talking about the creation of America's scripture. And we are finishing up the Bill of Rights today, believe it or not. That means we've got about probably a couple of weeks left. We're going to go through the 17 amendments. Won't spend a long time on that, except for maybe the 14th Amendment. And then I'll be starting a whole brand new series of lessons preparation presentations on the Civil War. I know some people have been asking me to do this for some time, and I've been working very diligently on it. I hope it'll be something interesting. But today we're going to finish up the Bill of Rights. We're going to talk about the Seventh, Eighth, Ninth, and 10th Amendments. Now, the Seventh Amendment is really it's one of those amendments that people don't pay much attention to because it's pretty cut and dry. It reads as follows: in suits of common law where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court in the United States than according to the rules of common law. So, what does this mean in plain English? Well, actually, Madison added this to Article 3 in the original Constitution, and the framers took it out. They didn't like it there. And so they took it out. And so it was later on added as a separate amendment. And as you can see, there's actually two clauses in this amendment. The first one is what's called the preservation clause, declaring types of cases juries are required to decide. So, under the Constitution, in a civil court of law, in a federal civil court of law, anything that amounts to over $20 has to be decided by a jury case. And then there's the reexamination clause, which says the federal judge cannot overturn a jury's decision. So that's in federal cases. This is one of those amendments that has not been incorporated. That means it has not been applied to the states because in Walker's versus, I believe you pronounce this Savant, Sonnet something, 1875, they ruled that the states are not required to provide jury trials in civil cases, although most states have already done that. Most states now allow for jury trials in civil cases. Uh, you can decide not to have a jury trial, but in most cases, you can ask for a jury trial in a civil case. Or you can go before Judge Judy. Just laughing. Okay. So, Seventh Amendment is pretty non-controversial. The Eighth Amendment has been a pretty litigated amendment. It basically reads: excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. So now we're going to get into the death penalty. This is where the Eighth Amendment comes in. The amendment serves as a limitation upon the state or federal government to impose unduly harsh penalties on criminal defendants before and after a conviction. And this amendment reads almost identical to what's in the English Bill of Rights that was passed in 1689. Now, the excessive bail component as well as the excessive fine component have never been too controversial. There have been some legal cases that have ruled on it, but it's nothing that's really generally too controversial. Obviously, the big controversy in this stems from the cruel and unusual punishment component. That is the one that's drawn the attention of most federal cases. So let's look at some of the federal cases that have come out of the Eighth Amendment. And the first one is Robinson versus California, 1962. In this case, the Eighth Amendment was incorporated to the states. In other words, the Supreme Court ruled that through the language of the 14th Amendment, states now had to make sure and not institute cruel and unusual punishments. What happened in this, I don't have the case down because we're just not going to deal with it. But what happened was Robinson was a drug addict, and he was arrested for being a drug addict. He wasn't under the influence of drugs. He didn't have drugs on him. They stopped him in a vehicle. He had tracks in his arm. Uh, he wasn't under the influence. He didn't have drugs in his car or on him, but they arrested him anyway for being a drug addict. And the Supreme Court eventually came back and said, you can't do that. Yes, he probably did break a law at one time back in the distant past, but you can't convict him for something that happened a long time ago when he's not presently doing. So that's how they incorporated it to the states. Not much happened with the Eighth Amendment until this one. This was the biggie, folks. Furman versus Georgia, 1972. The Supreme Court had a death penalty case before them. A guy in Georgia pleaded his case all the way up to the Supreme Court that he thought the death penalty in Georgia was cruel and unusual. So let's look at this case, because this is considered one of those landmark cases in Supreme Court history. Okay, so here's what happened. William Furman was burglarizing a house, and he had a weapon with him. And so he got inside the house, and the resident in the house, came out, saw him. There was a scuffle. The guy, Furman, was escaping out the window that he'd come into, and in the process, his gun went off. It was an accidental discharge, but nevertheless, it discharged and killed the resident. He was convicted of murder and sentenced to death. Now, the Supreme Court eventually got the case, and the question they had to determine was, does the death penalty constitute cruel and unusual punishment under the 8th and the 14th Amendments? And they ruled in Furman's behalf. They said in this particular case, it was cruel and unusual to put him to sentence him to the death penalty. Now, here was their reasoning. They said, we're not going to outright ban the death penalty. That's what the Supreme Court said. But in specific cases, which in this case, it was probably racially applied, they said. There was probably a racial component here because the resident was white, Furman was black, and they felt like, that there was a racial component going on here. So they placed what was called a moratorium on the death penalty. They said until the states can arrive at more consistent applications of the death penalty, then we're going to put a halt to the death penalty in the United States. The effect was that everybody sitting on death row at that time had their sentences commuted to life imprisonment. So guess what? Charlie Manson, sitting on death row in California, was in this 2-year window that we're going to talk about here in a minute. The result was that his case was commuted to life imprisonment. And of course, we all know that Manson lived, it seemed like forever. He was a young man, actually, when he went to prison for what happened out there in California. And then it's only been a few years ago that he actually died. So instead of being sentenced to death because of the Furman versus Georgia case, he got caught up in this 2-year moratorium where all the death penalty cases were, commuted to life imprisonment sentence. Okay, 4 years later, 1976, another case out of Georgia came before the Supreme Court. They had redone their death penalty cases, and they said, okay, we are now going to reinstitute the death penalty. And of course, Greg, the defendant, said, well, it's still cruel and unusual. And he appealed all the way to the United States Supreme Court. And Supreme Court had to once again rule whether or not the death penalty in the state of Georgia was cruel and unusual. So let's look at this case. What happened here was Troy Gregg was found guilty of murder. And, he was clearly, they've had him pretty well, dead to rights. He appealed his case to the Supreme Court, arguing, he said, whether I did it or I didn't do it, it's cruel and unusual. I should be put to death. So the question once again was, did the death penalty violate the 8th Amendment, which forbids cruel and unusual punishment? Now the court reversed itself. It said 7-2, the death penalty did not violate the Eighth Amendment under all circumstances. So why did they do this? Why did the Supreme Court change its mind? Well, here's why. They said Georgia has now implemented certain rules that, have that make it fair. And so we're not going to say that it is illegal and cruel and unusual people to death under these circumstances. Number one, and the most important element was that they had a separate trial. If you know anything about death penalty cases, there's always a second phase. There's the first phase of guilt and innocence. There's the second phase, what they call the penalty phase. And so, they kind of have a whole new case, a whole new trial to decide whether or not the case warrants the death penalty. And in this case, they said, hey, they've done it right. They had a second trial. And so they lifted the moratorium in Furman versus Georgia. And they said states can once again reinstate the death penalty as long as they've set up certain guidelines that make sure that it's being fairly applied. By the way, in case you're wondering what state was the kind of state that set the initial guidelines that most states since that time have copied, it was the state of Missouri. If you don't know, Missouri is one of the leading states in the nation for executing prisoners. They do it quite frequently. Texas and Florida are number one, but number 1 and 2. But I think Missouri may be number 3. I'm not for sure. Could be Tennessee, but there's definitely Missouri's right up there. If you look at the map over here, you'll see the death penalty is legal, illegal, and the moratorium. What states? And I don't know, this map is not too old. I can't remember what date it was now. But if you'll notice, the states in green, the death penalty is legal. And the courts have basically ruled in those states it is permissible to put people to death as long as you follow certain guidelines. In the blue states, the death penalty is illegal. So Washington, Colorado, New Mexico, Arkansas, Hawaii, all the upper Midwest states here, and of course, most of the New England states, the death penalty is illegal. In the orange states, Oregon, California, and Pennsylvania, the death penalty is legal, but the states have placed a moratorium on their own. In other words, they basically have said, we have a death penalty, but we're going to place a moratorium on the death penalty in these states. So, if there's a story here. Supposedly, you've probably all heard of Ted Bundy. Ted Bundy was probably one of the most notorious serial killers in America, and he did most of his crimes out here in the West, Colorado, state of Oregon, Washington, and these areas out there here, Seattle and Colorado, and some of these states like this. He was in prison in Colorado, and he asked the jailer, he said, or his lawyer said, what state is the most likely to put you to death? And the lawyer was interpreting this as being he wanted to know where he could go, where he shouldn't go to kill other people if he ever got out. He did eventually escape the jail where he was. Guess where he went? He went straight to Florida, which is one of the states in America where they put you to death pretty rapidly, and the death penalty is applied quite frequently. There's a feeling that he wanted to be caught, and he wanted to be executed, and so he wanted to be stopped. And so the reason he went to Florida had this in his mind. Now, I don't know if that's true or not, but that's the story anyway. So that's Gregg versus Georgia. So right now, the death penalty is legal in most states in the United States. That doesn't mean it's always applied. There's a lot of states that don't really use the death penalty, even though it's on the books. So there's been some other cases that have to do with cruel and unusual punishment we need to mention. One of them was in 1987, McCleskey versus Kemp, which they prohibited systemic racism in carrying out the death penalty. I'm not going to go into the details, but basically they set some restrictions on just exactly make sure that one race was not being unfairly targeted with the death penalty. And then there was the Payne versus Tennessee case, which allowed victim impact statements in the death penalty cases. I think we're all familiar with this now, where in these cases, a victim in the penalty phase of the trial, victims, families, whatever, can come in and give impact statements to the jury. These are usually highly emotionally charged and usually have a big effect upon the jury. And the Supreme Court has said these are legal in the death penalty phase of the trial. And then you have Atkins versus Georgia, the Georgia case, where they ruled that the execution of mentally retarded criminals is prohibited. So if you can prove that your client, if you're a lawyer and you can prove that your client is mentally, uh, you know, not able to think rationally, cognitively, then they probably are not going to be charged. Roper versus Simmons, I believe this is out of Oklahoma, execution of juveniles was prohibited. So you can no longer execute juveniles in the United States. And then we had Kennedy versus Louisiana, capital punishment reserved for the worst of crimes. Um, they ruled in here, said you, even if it's murder, uh, whatever, there has to be several components. In other words, basically, one crime by itself is not enough. You normally need to be able to show that there was multiple components to the crime, like kidnapping and murder, kidnapping and rape, etc. Things like this. Perhaps multiple victims, multiple times that the crime was committed. So this is what the Eighth Amendment does. So let's move on to the Ninth Amendment because this is a biggie. Okay. Now, the Ninth Amendment probably has been applied in ways in which I can almost guarantee you the framers never thought it was going to be applied. Okay. I'm not trying to show my political bias here. I'm just making a statement that I can almost guarantee you that when the framers wrote the Ninth Amendment and it was approved, they probably never foresaw how the Supreme Court was going to interpret the Ninth Amendment. That doesn't make it wrong. That just means that probably if you're interpreting the Constitution, as it was originally framed, it's probably not how they intended. In other words, this goes back to this originalism concept. So here's what the Ninth Amendment says. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So what is this? What does this mean? Well, when the founders looked at the original Constitution and the people started looking at it, they said, we're not for sure that all the bases have been covered here. They said, we want to make sure that future generations cannot come back and argue that because a certain right was not listed, that it did not exist. In other words, they said, we want to make sure that, that just because something wasn't said here doesn't mean it doesn't exist. They were kind of thinking, I'm sure, into the future. They were probably thinking, there's going to be things that are going to come up that society is going to change, technology is going to change, whatever. And we want to make sure that, just because the right hasn't been denied or given, to the Constitution, that it still isn't there. Now, the amendment's generally been regarded by the courts as negating any expansion of governmental power. But at the same time, it doesn't limit governmental power. It's kind of confusing, I know. In 1965, the court began asserting that the Ninth Amendment was relevant to the interpretation of the 14th Amendment in the case of Griswold versus Connecticut, when they ruled that citizens had a right to privacy. Now, this had been a right that had been talked about for some time, clear back in the late 19th century, early 20th century. I believe Oliver Wendell Holmes on the Supreme Court was the first one to talk about the right to privacy. And he said Americans have a right to do certain things in the privacy of their lives, which the government cannot keep you from doing. Well, in 1965, the Supreme Court got a case, Griswold versus Connecticut, and this opened the door to right to privacy cases, which led to abortion. So let's look at Griswold versus Connecticut. Estelle Griswold was the head of Planned Parenthood in Connecticut. Now, at that time, it was illegal to dispense birth control devices in the state of Connecticut or offer counseling. I know this probably sounds just absolutely wildly crazy, but sure enough, folks, as early as 1965, the year I graduated from high school, it was still illegal in the state of Connecticut to dispense any drug, medical device, or other instrument furthering contraception. So she was arrested and convicted, and she appealed her case. And the Supreme Court had to rule, does the Constitution under the Ninth Amendment through the 14th Amendment protect the right of marital privacy against counseling in the use of contraceptives? And they ruled 7-2 that there was a violation of the right to privacy as inferred in the Ninth Amendment. Now, nobody got too excited about this because, let's face it, birth control pills were new on the market in the early 60s. And, most people were probably glad to see it happen because, obviously a lot of people didn't want to have children or a certain number of children. And so they felt like there ought to be a medical way to keep that from happening. And that was what contraceptives did. William Douglas wrote in this case, the very idea of restricting the notions of privacy surrounding the marriage relationship is repulsive. That in itself wasn't so bad. What happened was this. This led to the Roe v. Wade case 8 years later, when the court ruled that abortion was also a protected right under the Ninth Amendment. So, 1965, the Supreme Court rules that contraception is legal and that is under the right to privacy. So, let's move on to the next case. 1972, Eisenstadt versus Baird, distribution of contraceptives to unmarried individuals was allowed. It used to be, I can remember that it was hard to get birth control pills in the late 60s unless you were married, unless it was prescribed for another reason, which did happen a lot. Okay. We won't get into it, but, it's a delicate situation, so we're not going to talk about it. Okay. 1973, Roe v. Wade, allowing abortion. This is probably, maybe, along with Dred Scott and Plessy versus Ferguson, probably the most controversial Supreme Court case that's ever been decided, because it has aroused so much passion in the part of people. People on both sides are just thoroughly impassioned by it. And I think we all know that. I mean, we've all lived with Roe v. Wade and the abortion question for the last, 50 years. And we know how impassioned people get about this, about this argument. Here's what happened. 1970, Jane Roe, that was not her real name. We know her real name now. By the way, she did come out later and said that she actually became a anti-abortion activist. But Jane Roe at that time sought an abortion in Texas and was denied. She sued and took her case all the way to the United States Supreme Court, claiming her right to privacy was guaranteed by the Constitution and that it had been violated. So, does the Constitution recognize a woman's right to terminate her pregnancy by abortion? They decided 7-2 in Roe's behalf. Harry Blackmun wrote the opinion, and he said abortion was protected by the Constitution, and he said, here's the parameters, here's the curbs, here's the guidelines. Number one, the first trimester, the first 3 months, only the pregnant woman and her doctor can make that decision. So they said in Roe v. Wade, it said the woman and the doctor are the ones that make the decision in the first 3 months. In the second 3 months, the state can begin to impose regulations that are reasonably related to maternal health. In other words, if if the state feels like that there are certain reasons that you should have an abortion because it's dangerous to the woman, then it's allowable. The third trimester, the state can regulate or forbid abortion once the fetus reaches the point of viability. That's the big question, folks. What does viability mean? Okay. And we're going to talk about that because later on the court begins to talk about this. But like I said, there has not been any case in modern history. I can guarantee you, Plessy versus Ferguson and Dred Scott were ruled in the 19th century on segregation and slavery and all this. Those were controversial in that century. There's not been anything any more controversial than the Roe v. Wade case in modern American history, and still is. It is still just, it's an extremely heated case in American history. So, what comes next? Planned Parenthood versus Danforth. This is a Missouri case. Consent of a spouse is not required. So a woman does not have to have the approval of her husband if she and the doctor decide that an abortion is warranted. The husband has absolutely no rights when it comes to that. That's what the Supreme Court said. And then in another Missouri case, Webster versus Reproductive Services, they begin to outline exactly what kind of restrictions can be placed. In Roe v. Wade, they said there can be restrictions, but they didn't name them. Okay. Now in Webster, they're going to start naming them. So let's look at the Webster case. Okay. Number one, in 1986, Missouri enacted the legislation that placed a number of restrictions on abortion, including number one, life begins at conception. Missouri law says that. Number two, forbid public employees or facilities from being used. It said, we're not going to let you use public facilities, and we're not going to let you, public employees, if you're going to get an abortion in Missouri, it's going to have to be done through a private situation. It forbid counseling advocating abortion, and there has to be test of viability after the 20th week. So they said, you can't just say it's viable or not viable. You have to start doing tests. So, did the Missouri law infringe upon the right to privacy as guaranteed in Roe v. Wade? And the court held 5-4, very narrow decision, that the Missouri restrictions did not infringe on the right to privacy. Pardon me while I get a drink here. Justice Rehnquist, he wasn't the Chief Justice at that time, wrote the Constitution did not require states to enter into the business of abortion and did not create a right to governmental aid in the pursuit of abortion. In other words, it said, you may be able to get an abortion in the state of Missouri or any state, but that doesn't mean the government is in the business of making it happen. So if the state doesn't want to pay for it, if the state doesn't want to let its employees do it, then, they have that right. The court emphasized, though, it was not revisiting the essential portions of Roe v. Wade. So they did not overrule Roe v. Wade. The big thing that came out of this was test of viability. In other words, they said, if you can prove after a certain period of time that that fetus could live outside the womb, then you can stop the abortion in that state. So that was how it happened in Webster versus Reproductive Services. Missouri has always been one of the leaders in the abortion case law, just like they've been one of the leaders in the death penalty case law. I don't know what that says about Missouri. Okay, I'm picking on Missouri because I'm originally and spent most all my life, well, all but the last 7 months in the state of Missouri. So I can pick on it. Okay, Hodgkin versus Minnesota. Consent of both parents of a juvenile are not required. That one was really controversial. Juveniles can get abortions under certain circumstances. And in this case, they said it doesn't require both parents. If one of the parents consents to it, it can happen. And then there was another case that came up in 1992, which had to do with placing restrictions on abortion. Planned Parenthood versus Pennsylvania versus Casey, 1992. Laws cannot place an undue burden on women seeking abortion. So here's what happened in that case. Pennsylvania passed some pretty stringent laws against abortion. Um, Pennsylvania has a high number of Catholics in the state. And of course, I think we're all aware that the Catholic Church is anti abortion. They've clearly stated that it's not within the realm of their religious instruction. As a result, Pennsylvania, which is normally kind of regarded as kind of I won't say a liberal state, but it's kind of like Missouri. There's two Pennsylvanias. There's Pittsburgh and Philadelphia, and there's the rest of the state. Missouri, you got St. Louis and Kansas City, and the rest of the state. Okay. Well, what happened was they passed a pretty stringent law. They said a 24-hour waiting period was necessary. So you can't just walk in and get an abortion on that day. You have to wait 24 hours. Let your emotions, kind of die down and make sure you're doing the right thing. Number two, there has to be informed consent. That means you have to make sure and let the person know what's going on. Okay, I know that sounds silly, but that's what they said. Parental approval of a minor seeking an abortion. Now they said if a minor is going to have an abortion in the state of Pennsylvania, then one of the parents has to give consent. There's not going to be any of this situation they said in Pennsylvania where minors can get an abortion against their parents' wishes. Not all states are like that. Notification of both spouses prior to an abortion. Planned Parenthood sued. So the Supreme Court had to rule, did the Pennsylvania restrictions violate the right to an abortion guaranteed in Roe v. Wade? And the court ruled 5-4 in the state's behalf, except for the one where they had to have notification of both spouses. They said that one is not going to fly. The other ones are legal. That one's not going to fly. So, while again reaffirming Roe, the court upheld most of the Pennsylvania law. It imposed a new standard to determine the validity of laws restricting abortion by adopting an undue burden test, which said any substantial obstacle in the path of a woman seeking an abortion prior to viability, that it's going to rule that those are illegal. So what it's saying is the states can put restrictions, but it can't be so restrictive that it will keep a woman from having an abortion as long as they meet these other guidelines up until the time that the fetus is viable, can be, live outside the womb on its own. And then there was Stenberg versus Carhart. Partial birth abortion was upheld. That is a really controversial case. A lot of people, are really upset about this case. They think it was unnecessary and it shouldn't have ever happened. And then the biggie, 3 years ago, Dobbs versus Jackson's Women's Health. The court ruled that the Constitution does not confer of a right to abortion, overturning Roe v. Wade and returning the authority to regulate abortion to the people and the states. So, a lot of misconception about what this case said. So let's look at it. Dobbs versus Jackson. In 2018, Mississippi passed a law banning all abortions with few exceptions after 15 months. I think I've got that wrong. Okay. The Jackson, I think that should be 15 weeks. Okay. The Jackson, Mississippi Women's Health Clinic sued, stating the law violated Roe v. Wade. So Mississippi passes an extremely restrictive law saying after 15 weeks, there are almost no exceptions that will be granted. Question: was Mississippi's law unconstitutional? Did it violate the Roe v. Wade question? And the court, in a 6-3 decision, held for the state, and in the process overruled Roe v. Wade. Now, a lot of people said it was one thing when they ruled Mississippi's law was constitutional, but then they went on ahead and overruled Roe v. Wade, said it was bad precedent. Samuel Alito wrote the Constitution does not confer a right to abortion. He just outright said the Ninth Amendment doesn't say anything about abortion. The framers didn't intend for it to say anything about abortion. And it doesn't, we're going to interpret it as not granting the right to abortion. And he set down 5 factors. He said, here's what has to happen if you're going to overturn a precedent, because Roe v. Wade was precedent law. He said, number 1, if it short circuits the democratic process. In other words, if the will of the people has been short circuited, then it's not right. There has to be constitutional text that supports the precedent. And he said nowhere in the Constitution does it even remotely come close. It's one thing to interpret the right to privacy, he said, but it's another thing to interpret abortion out of the right to privacy. And then the test were not workable. They said these undue burden tests and all this kind of stuff, he said, is gobbledygook. It doesn't really tell you what is viable. It caused a distortion of law, and overruling them would not upend concrete reliance interest. I'm not even for sure what that means. I'm not a lawyer, so I can't really tell you what all that means. All I know is this. This is what happened as a result of the Dobbs case. The right to abortion under the 9th Amendment through the 14th Amendment was ruled non-constitutional. And so what happened was they threw it back to the states. They said, we're not saying a state can't outlaw abortion or allow abortion. We're saying that's something the states should be taking care of. So as of September 2023, and I don't think this has changed a whole lot. Here's what the situation is in the United States, the way I understand it. The real dark red states, mostly southern, few up here in the Midwest, Idaho, surprisingly Minnesota, Wisconsin, some of the border states, these are where the most restrictive states are in abortion. A lot of people think that Missouri is probably the most restrictive state in the nation when it comes to abortion. The legislature in Missouri is extremely anti-abortion right now, even though the people voted in the last election to allow abortion. They're still trying to figure out ways to keep it from happening. Okay. The states that are in dark orange are very restricted. States like Nebraska, Georgia, South Carolina. The states in medium orange or yellow are restrictive. Florida, Nevada, Montana, Wyoming, Michigan, some of these states like this, New Hampshire, some of these states like this are fairly restrictive. And then you've got states that are protective. The ones that are kind of the teal are reasonably protective of abortion. States like Oregon and Colorado and Illinois and Maine and Connecticut, you know, Massachusetts, some of these. Very protective states are those that are in the medium blue here. And then you've got those that are extremely protective, okay? And that would be states like Washington, which is probably one of the most, one of the states that has the most protection. Pardon me, I think that's a word. Got my states mixed up here. Okay, so that's where we're at that point. So I hope I've kind of cleared this up for you if you've been confused. Now, there's a couple of things we need to talk about. In addition, the Ninth Amendment deals with the other end of the spectrum, which is we always think of the Ninth Amendment as being when does life begin? There's another question out there about when life ends. Okay. And this was again settled in the state of Missouri. Cruzan versus Missouri, 1990. I bet a lot of you remember this case. The parents had a daughter that was in what was called a persistent vegetative state. They had to make a decision about whether or not they should pull the life support. And for whatever reason, the somebody got involved and said, no, that's not for them to decide. That's for the state to decide. And one of the outcomes of this case was health directives, what we call living wills, what we used to call. What happened was this. Basically, they ruled that the state does have an interest in determining when a person, when parents and spouses or whatever, children can, make a decision about withdrawing life support. Since that time, more people have just kind of used their wisdom, and it's basically one of these situations where doctors and the relatives make the decision. But in Cruzan, the state got involved in it. The court also held Washington's ban on assisted suicide. In 1997, ruled the Ninth and 14th Amendment did not protect a person's right to die, but did leave the door open for individual states to either permit or ban physician-assisted suicide. And again, a lot of states have now begun to allow, assisted suicide. And you can see here, that's, by the way, that's Nancy Cruzan. The dark blue states, assisted suicide is legal. And you can see the West Coast, New Mexico and Colorado, and some of the New England states, Hawaii. The red states, basically, where aid and dying is illegal. And there's one state where there's a legal court ruling saying it is legal, but the state itself has not said so. So, that's where we're at on assisted suicide and the right to die. One more case, and then we got to stop. 10th Amendment reads as follows: the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, or reserved to the states respectively, or to the people. So what in the world does that mean? This amendment expresses the concept of federalism by reinforcing the principle that the federal government does not have any rights that it does not have. Now, what does that mean? It means that the federal government just can't start assuming rights. The Supreme Court has ruled that the 10th Amendment prohibits the federal government from forcing states to pass or not pass laws. So the federal government can't tell the state of Missouri to pass an abortion law. They can't make you do that. In Prince versus U.S., the court ruled that the Brady Handgun Violence Prevention Act violated the 10th Amendment since it required states to conduct background checks. One of the elements of the Brady Law that was passed under back in the early 90s was that the federal government said every state has to pass a background check law. And the Supreme Court came back and said you can't do that because the 10th Amendment says the federal government doesn't have that right. You cannot force a state to pass a law. Now, this has led some legal scholars to believe the states have a right to nullify federal laws. Now, we're going to get into nullification if you stay with me through the Civil War, because nullification became a big thing back in the 1830s. But basically, there's some people that think states have a right to declare a law unconstitutional in their state. Most people don't think that. But there are certain states. Missouri, believe it or not, had been right in the middle of this one too. In 2023 or 21, they passed a law called the Second Amendment Preservation Act, which attempted to limit the state's role in enforcing federal gun laws. They said the federal government has passed certain federal gun laws, and we're going to tell you that in the state of Missouri, we're not going to enforce those laws. Kind of a backhanded nullification. The Supreme Court came back and said, you can't do that, Missouri. Just like the federal government can't tell you what to do, you can't come back and tell the federal government you're not going to obey the federal law. There's certain ways that this works. By the way, not very many people talk about it, but this is what's going on right now with sanctuary cities and whether or not states and cities can assist the federal government in arresting illegal aliens. And basically the law says they don't have to. If the state or the city has passed a law saying we will not assist the federal government, ICE, in detaining these people, then that doesn't, you can't require them to do it. Now, that doesn't mean the federal government can't come in and arrest the people. It just means the state can't be forced to assist them. It doesn't mean the state can't assist them if they desire to, which a lot of states do. A lot of states don't. Okay. Well, I hope I made this just clear as mud for you guys. I hope that somehow along the line you've got some of these things figured out. We're done with the Bill of Rights. We're going to spend about 2 weeks on the next 17 amendments. We're not going to spend a long time on these. We are going to spend some time on the 14th Amendment, because the 14th Amendment is very critical to the Bill of Rights. But other than that, we're going to go through these pretty rapidly. So we ought to be with this for about 2 more weeks, and then we're going to switch gears, and we're going to begin talking about the American Civil War. This will take a few months, and I've been working on it diligently the last few months, and I'm not bragging, but I think it's going to be pretty good. So I hope that you'll spread the word out there. So with that, I'm going to stop, and I will see you next week. And so long.